Alright, Bill Henshaw here for the Constitutional Crisis Channel, and I wish all of you season's greetings out there. And I'll even go so far, by the way, as to say Merry Christmas these days. Something where I am, you don't see any of these signs in the stores, nowhere, nothing. It's like it doesn't exist. Weird. But it is the 23rd of December, and here we have current events, yet again, a frequent topic of these discussions. This case involves the case of Sandra Bland in Texas, where they just came back. The grand jury did not file indictments against any of the goons that were involved in this case. If you're not familiar with it, and I'd like to learn a lot more about it myself, but the facts I do have at hand, this emanated from a traffic stop. You know, like running through a stop sign or not having a tail light, you know, something stupid like this. And this guy, for whatever reason, refused to get out of the car. And this goon with a 7-star suppository on his chest, you know, threatens her and says, "You get out of the car or I'll light you up," meaning he's going to use his taser on her for something that wouldn't have been more than probably a $50 fine. Don't they teach limitations on violence down there with these Texas peace officers? Geez, I mean, right away you have to wonder. Now, if this Ms. Bland happened to know anywhere near what I know about the system and she knew the courts didn't have jurisdiction, she was on very good ground, and they will be hearing from me about this. Because I said before in other videos, and I'll mention it briefly here, the case is John Badoff versus United States, 177 U.S. 529, where the Supreme Court reversed a conviction in not the territory of South Dakota, but this happened on an Indian reservation after South Dakota was admitted as a state. And they reversed the conviction because the cop involved trying to arrest Badoff didn't have probable cause, didn't have a warrant, didn't have anything. Badoff, therefore, had a right to self-defense, and he exercised it in this case, and the cop got killed. And at the end of the opinion, the court even says at the end that we're not even sure that you could sustain a case for voluntary manslaughter under the facts of this case. Now, who knows whether Ms. Bland knew any or all of this. If she did, like I say, she's on very good ground there, and they will be getting a long letter from me saying, "Hey, what are you people doing here? I mean, excessive force? Jeez." So the grand jury doesn't come back and indict anybody, and that's the sole charge they had pending is against this goon at the scene of the crime at the traffic arrest, threatening to light her up by using a taser, which would have been excessive force. I mean, my goodness, I mean, especially without any jurisdiction in the courts for the case you're going to bring if you arrest her. So right now it's very sketchy. I don't know why the grand jury didn't. I don't know what exactly the charges were that were presented to the grand jury. Hopefully a lot more of this will come out to figure out why they didn't take any action, especially with the spate of violence, as you all know, over the last year and a half from coast to coast, mostly against, you know, black people, and most of them black men. But don't be misled here, because they can do the same thing to anyone else they choose, the way this system currently runs. So yes, I certainly agree on the surface it looks like a Black Lives Don't Matter issue. The real issue is the lives of none of us matter. The government all thinks that they're the masters and we're the servants, or if you want, guardians and wards, or even more graphically, masters and slaves. It hasn't changed much from 150 years ago. Until that mindset and that philosophy does change, these are the kind of things that are going to happen. And I've got a quickie here, by the way, and I'll have to get this one to you in the notes below, because I read it and I don't recall it off the top of my head right now. But it had a case, it was all involved in the Supreme Court. It was a civil rights case, and it was brought, I think it came out of New York. And you know, you had cops breaking in to the wrong apartment without a warrant, without anything, and no probable cause. And you had people that were arrested and jailed. I think one of them actually got killed, and they sued under good old Title 42 USC 1983. Look this one up in your law library, people. It has 2.5 thick volumes of books. One law, all to itself. Totally useless. The government loves it. They want you to use it, which is reason enough for you not to. But during the arguments behind the scenes in the Supreme Court, Windfish was making the argument that civil rights didn't apply here because there hadn't been any loss of life. Wait a minute, didn't somebody get murdered? Well, yeah, they did. But from the perspective of civil rights, since civil rights only applies to rights that are granted by government, is the right to life granted by government? Apparently it is. If you owe your citizenship to the 14th War Amendment, then it may be that you do. But then again, people will recognize, and most juries will recognize, that life is a creator endowed inalienable right having nothing to do with the government. I mean, this is a big time deal. I think Rehnquist was right on about this. He was trying to make a point here in a difficult way, I'll grant you, and he didn't do a very elegant job of it in this particular instance. But nevertheless, that's the right issue because, there is no right to life like that. And this, by the way, strikes me as very similar reasoning to what would have happened had the case of O.J. Simpson reached the federal courts with his murder of Nicole Brown. The same thing would have happened because, and there wouldn't have been double jeopardy there because he was tried in a quote-unquote state court. And had they filed civil rights charges, which is all they could do, Nicole Brown, being white, didn't have any civil rights to violate. And I'm sure that argument would have been dead bang front and center, and it would have embarrassed everybody. So I think that's why it wasn't filed that way, though it could have been. But nevertheless, that's the thing. And without, since he murdered her, that's a charge for a state court. Murder, not Penal Code 187 like we have here in California. Forget about that. Not a statutory crime. Comes under the Ten Commandments, it would seem to me. So that said, there is no right to life involved there. Someone knocks you off on the street that, has a badge and a gun. Your chances of getting a recovery here are almost slim to none here. I would much rather us get out there and start to file, if we can get our state common law courts back, what's called a trespass viat armis, by force of arms. That's in a judicial court, and these bastards don't have any immunity against us in that setting like they do with civil rights cases. All this damn immunity they have, and only on rare occasions can you get around it, and it's unusual when it happens. In a common law court, look out. Because if you're acting out there without any jurisdiction and you knew or should have known, then you're the one that's going to go to jail, or you're the one that's going to get 20,000 volts. And it doesn't matter whether you got properly trained or not. Don't they constantly tell us ignorance of the law is no excuse? Why should it be for them? Now, we'll follow up on this case in Texas about this with Ms. Bland as soon as we hear more news about it, and it hasn't come out yet, but I'll be doing another video when there's a meaningful time to do it. Thank you.